Question 67. The Deterrent Theory of Punishment. Introduction. Understanding the purpose of punishment. Punishment, in the philosophy of law and criminology, serves as society's response to crime. It is not merely an act of retribution, but a method to maintain order, protect society, and prevent further wrongdoing. Among the classical theories of punishment, retributive, deterrent, preventive, and reformative, the deterrent theory occupies a central place. It focuses on the prevention of crime through fear, arguing that punishment should be severe enough to discourage both the offender and others from committing crimes. In essence, the deterrent theory of punishment sees punishment as an instrument of social defense rather than revenge. 1. Meaning and definition of deterrent theory. The word deterrent comes from the Latin deterrere, meaning to frighten away. Thus, the deterrent theory of punishment holds that the primary objective of punishment is to prevent crime by creating fear of consequences. According to Jeremy Bentham, a leading utilitarian thinker, the purpose of punishment is not to torment the wrongdoer, but to prevent similar offenses in the future. Hence, the deterrent theory focuses not on the past act, retribution, but on future behavior, prevention. Simple definition. Punishment should be of such a nature that it discourages both the offender and others from committing crimes out of fear of suffering the same consequence. Two main objectives of the deterrent theory. The deterrent theory rests on two broad objectives. I. To deter the individual offender, specific deterrence. The punishment aims to discourage the particular criminal from reoffending by making him experience pain or loss. Example: a thief sentenced to jail may refrain from future theft because of the fear of imprisonment. 2. To deter others in society, general deterrence. By punishing one offender, society sends a message of warning to others that crime will lead to suffering. Example: public executions or high-profile criminal trials serve to deter others who might be tempted to commit similar crimes. Thus, deterrence operates both individually and collectively through fear of punishment as a means of social control. 3. Historical background of the deterrent theory. The deterrent theory emerged during the classical school of criminology in the 18th century, influenced by thinkers such as Cesare Beccaria and Jeremy Bentham. Before this period, punishments were often cruel, arbitrary, and retributive. The classical thinkers argued that punishment should instead be rational, proportionate, and socially useful, that is, it should deter crime rather than avenge wrongdoing. Beccaria, in his famous work on crimes and punishments, 1764, argued, the purpose of punishment is to prevent the offender from doing fresh harm to others and to deter others from doing the same. Thus, deterrence was seen as a rational alternative to brutal or religiously motivated punishment. 4. Key features of the deterrent theory. I. Preventive in nature. Its chief aim is to prevent future crimes by instilling fear of punishment. 2. Fear as the core mechanism. The assumption is that human beings are rational and will avoid actions that bring pain or suffering. 3. Proportional punishment. Punishment should be severe enough to outweigh the potential pleasure or profit of committing the crime. 4. Exemplary effect. Punishment should act as a public example, warning others of the cost of criminal behavior. Rationality of the criminal. It assumes that individuals weigh consequences before acting and are therefore capable of being deterred by punishment. Example: a driver who sees a heavy fine imposed on drunk driving will likely avoid it, fearing the same penalty. Penalty. 5 types of deterrence. The deterrent effect operates on 2 levels. I. General deterrence. It aims to discourage the general public from committing crimes by making an example of the punished offender. Example: the death penalty for heinous crimes like terrorism or rape is intended to dissuade others from similar offenses. 2. Specific deterrence. It targets the individual offender to ensure he does not repeat the crime. Example: a convicted fraudster fined heavily may avoid future frauds due to fear of losing his wealth or liberty again. Thus, deterrence works through fear of consequences, both personal and collective. 6. Illustrative examples of deterrent punishment. Example 1. Death penalty for heinous crimes. The capital punishment awarded in cases of terrorism or brutal murder, such as the 2012 Delhi Nirbhaya case, is meant to deter others by demonstrating the ultimate consequence of such acts. Example 2. Imprisonment and fines. In most legal systems, punishments like imprisonment or monetary penalties for theft, fraud, or corruption are designed to discourage both offenders and potential criminals. Example 3. Strict traffic laws. Heavy fines and suspension of driving licenses for reckless driving serve as modern examples of deterrence in practice. Example 4. Public punishments in early societies. In earlier times, public executions, flogging, and pillory punishments were intended to shock and frighten people into obedience. 7. Philosophical justification of deterrent theory. The deterrent theory is grounded in utilitarian ethics, particularly Bentham's idea that punishment is justified only if it produces greater social good, i.e., prevents more harm than it causes. According to Bentham, all punishment is mischief, all punishment in itself is evil. It ought only to be admitted in as far as it promises to exclude some greater evil. This means punishment, though painful, is morally justified if it prevents a larger amount of pain, crime, in society. Thus, the deterrent theory aligns with the principle of utility to maximize happiness and minimize harm by discouraging wrongdoing. 8. Merits, advantages of the deterrent theory. I. Preventive effect. By instilling fear, it discourages potential offenders and maintains social discipline. 2. Social protection. It protects society by discouraging both habitual and prospective criminals. 3. Rational approach. It replaces vengeance with a rational and purposeful justification for punishment. 4. Psychological control. The fear of pain acts as a psychological barrier against unlawful behavior. Example: strict anti-corruption laws and enforcement create a deterrent atmosphere where officials hesitate to take bribes. 9. Demerits, criticisms of the deterrent theory. Despite its influence, the deterrent theory faces several criticisms. I. Assumption of rationality. It assumes all criminals are rational and calculate consequences. However, crimes of passion, mental illness, or desperation cannot be deterred by fear alone. 2. Ineffectiveness for hardened criminals. Habitual offenders or emotionally driven criminals are often undeterred by punishment. 3. Overemphasis on fear. Excessive severity may breed resentment, not reform. Fear may suppress crime temporarily but fails to change moral attitudes. 4. Neglect of reformative purpose. The theory ignores the need to rehabilitate offenders or address social causes of crime. Inequality in impact. Severe punishments may disproportionately affect the poor or marginalized, while the powerful evade deterrence. Example: the death penalty has not conclusively reduced the rate of murder or violent crimes, suggesting limited deterrent value. 10. Modern relevance of the deterrent theory. While modern penology emphasizes reformation and rehabilitation, deterrence remains an essential component of criminal justice systems worldwide. Example: stringent anti-terror laws, like India's UAPA. Harsh penalties for cybercrime and corruption. Public awareness campaigns that highlight the consequences of offenses, example, anti-drunk driving advertisements. Thus, in modern democracies, deterrence is combined with reformative justice. Punishment aims both to discourage crime and to reform the offender. 11. Indian perspective. The Indian Penal Code, IPC, embodies the deterrent theory, emphasizing punishment as a means of preventing offenses. Section 53 of IPC lists punishments such as death, imprisonment, forfeiture of property, and fine, all designed to create a deterrent effect. Indian courts have also upheld deterrence as a legitimate purpose of punishment. Example: in the Bachan Singh v. State of Punjab, 1980 case, the Supreme Court justified the death penalty as a deterrent for the rarest of rare crimes. However, the judiciary also acknowledges that deterrence must be tempered with reformation and human dignity, reflecting a balanced approach. Summary for quick understanding. The deterrent theory of punishment holds that punishment should prevent future crimes by instilling fear in both the offender and society. It emerged during the classical school of criminology, advocated by Beccaria and Bentham, and focuses on prevention rather than revenge. While effective in maintaining order, it is criticized for ignoring reformative and psychological dimensions of crime. Modern justice systems combine deterrence with rehabilitation, recognizing that fear alone cannot create moral obedience. Quick revision notes. Meaning: punishment to prevent crime by creating fear. Aim: prevention of future crimes. Thinkers: Beccaria and Bentham. Types: general deterrence and specific deterrence. Examples: death penalty, imprisonment, heavy fines. Merits: preventive, rational, socially protective. Demerits: overemphasis on fear, ignores reformation, assumes rationality. Modern view combined with reformative approach. Indian example: Section 53 IPC, Bachan Singh, 1980. One-line questions and answers for revision. 1. What does the deterrent theory of punishment aim at? Preventing crime through fear of punishment. 2. Who are the main advocates of deterrent theory? Cesare Beccaria and Jeremy Bentham. 3. What are the two types of deterrence? General and specific deterrence. 4. What is general deterrence? Deterring the public by punishing one offender. 5. What is specific deterrence? Deterring the same offender from reoffending. 6. What is the main assumption of deterrent theory? Humans are rational and avoid pain. 7. What is a common example of deterrent punishment? Death penalty for murder. 8. Which Indian law reflects the deterrent principle? Section 53 of the Indian Penal Code. 9. Which case justified the death penalty as a deterrent? Bachan Singh v. State of Punjab, 1980. 10. What is the major criticism of deterrent theory? It neglects reformation and moral change. Final connection. The deterrent theory of punishment reflects society's effort to protect itself by appealing to the human instinct of self-preservation through fear of consequence. While punishment as deterrence has been instrumental in maintaining law and order, it is now understood that fear must be balanced with fairness, and justice must aim not only to frighten the offender but to reform the human being within him.